Good afternoon.
Good afternoon.
My name is Herbert Israel. I'm from the New York State Attorney General's office. And today, this afternoon, my colleague Sandy Mindell and myself will conduct a training session for all of you, the would-be arbitrators in the state-run lemon law arbitration programs. And I will just begin a few minutes of introduction, a few words of introduction, and I will give over the floor to Sandy Mindell, and he will do his spiel. And after that, I will come back and we'll go through some of the things he said and add some other things, and that will be the session. So we hope to do it without any breaks, about 2.5 hours. That's unless you want a break, and we'll leave it up to you. So very first thing we have to do is thank all of you for coming and for volunteering to be arbitrators in this program. You are volunteers. Thus far, we have not been able to convince those that be to budget money for arbitrators. And therefore, we thank you, especially it's a public service that you're doing, and it makes the program as successful as it is. You should know that the state-run arbitration program is really 4 separate programs. There's the new car program, with new car lemon law dealing with the purchase of new cars, and we'll explain exactly what a new car is. Then there's a used car lemon law program, and it's a separate program. And then there's the lease program dealing with excess wear and tear, when the car is returned after a lease, at the end of a lease, or even surrendered earlier, and there's some damage, and the leasing company holds the customer or the consumer responsible for the damage, and the consumer wants to dispute that damage. So there's an arbitration program for that. And finally, there's the wheelchair lemon law, which deals exclusively with wheelchairs. There are very few cases under that program, but nevertheless, it is a program run by the Attorney General, and all of you will be qualified at the end of the day, and after you read the guides, to sit and arbitrate disputes in all 4 programs. Just a brief word of introduction on the new car lemon law. The new car lemon law is the statute which is in the general business law. It's section 198A. How many of you are attorneys? Oh, good bunch. Okay, so I don't have to be apologetic then. I cite statutes or we refer to cases. It's section 198A of the general business law. It was first enacted in 1983, and it was amended only in 1986 to provide for the arbitration program. Before that, all it did is require repairs at no cost to the consumer, but it didn't have a dispute mechanism, a way of arbitrating disputes until 1986, when the statute was amended. And it first went into operation in 1987. So we're almost 30 years into the program, and that program had a very rugged beginning. It was challenged by the industry and taken up and down the courts of the state and federal court, but upheld by the courts as a lawful and constitutional program. I only have the statistics here for last year. I didn't update them yet, but for 26 years of its experience, there were 30,000 applications filed under the new car alone, of which almost 3/4 were accepted. That's more than 21,000 individual applications and cases. But not all of them go to hearing, because many times you find that even after a consumer files an arbitration form and requests arbitration, they settle. The consumer settles with the manufacturer or withdraws from one reason or the other. The car is stolen, is subject to, it's been in an accident or whatever reason there is, where it cannot complete the process, so it doesn't end up in a hearing, and even less than those who go to hearing end up in the decision. Again, because even after a hearing, there is still an opportunity for the sides to settle. And that happens on a number of occasions. But most, as you see, most of the cases that go to hearing do end up in a decision, and those are the decisions that arbitrators like you render. As a result of these arbitration decisions, there have been over $238 million thus far recovered for consumers under this program alone. All right, that's a basic premise of the background before I turn it over to my colleague, Mr. Mindell, as we refer to him, Sandy, has been with the Attorney General's office for over 50 years. And he's as sharp and as witty as he has been from the beginning, maybe a little more frail, but he is extremely with it, as the colloquial saying is. And he was very instrumental in reaching this legislation. He didn't draft the legislation, but he was very responsible for this and many other statutes in the state that are consumer protection statutes. So it's my pleasure now to introduce Sandy Mindell.
Herbert and I have been together for 40 years. He came into the office 10 years after I did. And so I really have two wives when I go home.
I only have one.
When I go home,
And it's not Sandy.
I spend my time arguing with my wife when I go home. When I come to the office, we've argued together 40 years. The only thing I take issue with what Herb said is that, in fact, I did have a significant hand in drafting the lemon law, the new car lemon law and the used car lemon law, on behalf of our office. The lemon law, which Herb mentioned, is in the general business law, was part of then Attorney General Bob Abrams' legislative program. And focusing for my major presentation on the new car lemon law, I just want to give you a little bit of legal background. After the lemon law was drafted, and we were the second state, Connecticut was the first state to have a lemon law, and now I believe every single state, 50 states in the United States, have a lemon law. Now, they're not all the same, and later on I'll allude to one area where there is a major difference, but manufacturers, attorneys try to, what shall I say, introduce to their benefit some of the language in the sister state laws into ours. So you have to be very careful when you're talking about the lemon law. We're talking about the New York lemon law, not the lemon law in Florida or California or what have you. They are all very similar, but there are some major differences. Now, when I drafted or helped draft the legislative committees, for those of you who are lawyers, I envisioned that what we were doing was drafting a law that was similar to the remedy of revocation of acceptance in the Uniform Commercial Code. How many of you are aware, how many of the attorneys here have heard of the remedy, buyer's remedy of revocation of acceptance? I'm sure many of you have. And when I wrote them, when the legislature passed the law, we had to submit on behalf of the Attorney General's office a memorandum in support of the law. So I'll tell you a very interesting anecdote. When I drafted that memorandum in support, urging the governor to sign it, I said that the lemon law that we passed, that was just passed by the legislature, was very similar to revocation of acceptance. The governor signs the law, And as Herb mentioned, the industry was not happy. I mean, if you think for the moment, there are not very many other areas where an arbitration, a compulsory arbitration, where the manufacturers and car dealers are dragged at the behest of the consumer to an arbitration hearing. There aren't too many areas in the law where that can happen. Normally, people have their day in court. So the manufacturers argued up to our highest court, the New York Court of Appeals. And what did they argue about primarily? They argued on the memorandum that I had written. They said, look, the Attorney General who helped draw the law and sponsored this law is saying that it's akin to revocation of acceptance. Well, revocation of acceptance is a legal remedy. You know, the distinction between law and equity. And if it's a legal remedy, we're entitled to a trial by jury. We're entitled to a day in court. We don't want to have the opportunity, not to have the opportunity to choose to go into court. Well, the Court of Appeals, in sustaining the Lemon Law, said that no, the memorandum was incorrect. This was not revocation of acceptance. What it was an action for rescission. So here I had egg on my face because I was trying to support the law on the basis that it was a revocation of acceptance remedy, and rather the court said it was an action for rescission. Why did it rely on that? It relied on that because an action in equity does not require a jury trial. The Court of Appeals said to the manufacturers, therefore, you do not have the entitlement of coming before a jury. The arbitration program can stand on the basis of an equitable remedy. But, said the Court of Appeals, this is a very unique kind of creature. It is compulsory arbitration, where one party, that is the consumer, can elect to either go to court or go to arbitration. As Herb said earlier, when the law was first drafted, the only remedy was a cause of action was created to give consumers the opportunity to go into court. What happened in the 3 years between 83 and 86 was that I don't think there were any cases, because attorneys, although the law provided that if a consumer was successful, they would get attorney's fees, the private attorneys did not want to take a chance and go in and expend time and effort and then not recover an attorney's fee, or, I mean, in the alternative, would have to charge a consumer a large fee up front the consumers weren't prepared to pay. We urged the court the legislature, we went back to the legislature 3 years later, and we urged them, we said, look, the concept is great. Concept of a lemon law is great, but it's a remedy without any real opportunity for consumers to use it. And we convinced them to follow the Connecticut version of compulsory arbitration. Well, said the Court of Appeals, if it's compulsory arbitration, and I think Steve Lalonde is an expert, and has been for many, many years associated with our program. I'm just looking for the language. The Court of Appeals, well, for the moment, I don't see. But the Court of Appeals said, you see, if it were an ordinary arbitration, Where's Steve? My eyes aren't so great. But Steve, you stop me if I'm mistaken. If it's an ordinary arbitration, it's governed by Article 75 of the CPLR, which is the arbitration articles. And that article has a provision in it which gives the losing party an opportunity to go to court and challenge the arbitrator's award. But the grounds that are set forth there are very limited. They are, for example, bias on part of the arbitrator, that the arbitrator was secretly was the uncle of one of the parties, or fraud. It was very, very limited. And the Court of Appeals said, we're not buying that. If we're going to have compulsory arbitration, we are going to require that the arbitrator's award be based on CPLR Article 78, which is an article which deals with actions brought against the state. So if the motor vehicle pulls somebody's license and that somebody doesn't like having their license pulled, they can go and they can challenge the motor vehicle department. The way they do that, they go into court, but they have to go in under Article 78. And the standard in Article 78 for sustaining an administrative body, like the Department of Motor Vehicles decision, is that it has to be consistent with due process. It can't be arbitrary or capricious, and there must be substantial evidence in the record to support it. Steve, is that about putting it accurately? So that means that your role in writing an arbitrator's decision, and incidentally, I'll point out another historical point. Court of Appeals, the New York Court of Appeals sustained the program. The program was then challenged in the Federal Court of Appeals, went up to the U.S. Circuit Court of Appeals for the Second Circuit, and cert was denied to the Supreme Court. It was challenged on due process grounds, and the Court of Appeals, the Federal Court of Appeals, upheld the law with respect to that it comported with due process. Interestingly, in that case, Chrysler argued that the court couldn't consider the record because there was no record, because originally, as the regulations were drawn, we did not require that the arbitrator make findings of fact. We amended the law, and I remember during the course of the argument, one of my colleagues who was arguing the case for us before the Court of Appeals called me to, said, Your Honor, during the course of the litigation, the Attorney General amended the regulations to provide that the arbitrator must make findings of fact, so that there could be a record in case there was an appeal to the court. And I was called up to the person arguing called me up. I was sitting in the audience and said, "This is Mr. Mindell. He changed the helped change those regulations, wrote those regulations. Isn't that so?" I said, "Yes," before a three-judge panel. And the court, in a footnote, pointed out that we now had amended our regulations so that the arbitrator's award must have adequate evidence. That means that your job in writing a decision for or against the consumer or the manufacturer, and I think now, Herb, what, the statistics are about 50-50, are they?
Yes.
Yeah?
Yes.
Yeah. They're about 50 in favor of the consumer, 50 in favor of the manufacturer. In the new car program, your role is not to make a skimpy record, because if that case goes up to the Supreme Court under Article 75. Because for all other purposes, our program is governed by CPLR 75, which is, as I said, the article which governs arbitration. If that goes up to the Supreme Court and the losing party has 90 days after the issuance of the award to appeal, the court has to have something to look at to determine whether or not the award was arbitrary and capricious, whether it was supported by evidence. Therefore, it's imperative for you in writing those decisions. I don't know, Joe has, where's Joe? Have the people seen, are they aware of the award forms?
They have a link in their guidebooks. I'm going to send them tonight.
Okay. You should look at the award forms. You will see that there is a space allowed which you are really obligated to summarize the evidence and to make your findings. There are some check marks at the beginning as to what issues are in dispute, and some check marks at the end as to what you base your decision on. But it's essential that you set forth a record so that in that arbitration decision, so that a court can have something to rely on. Incidentally, the regulations give either party the right to have a stenographer present, either longhand, I don't know, do they still do longhand? But anyway, video and audio recordings. If either party wants it. Neither party that I'm aware of, have any parties asked for that? Herb, I don't think we've ever seen that. The Second Circuit Court of Appeals in upholding due process said to Chrysler, you could have asked for a stenographer if you're complaining about the record. You didn't ask for a stenographer, so don't come here and argue to us that the record is skimpy. They wanted to uphold the law. The courts obviously where the judges drive cars and have kids that drive cars. And you know, until the law was enacted, the only thing you could do if you bought a car was to go in the, you know, the auto show used to be at the old Coliseum. There always used to be a news story where somebody would park a car with lemons all over it in front of it. Because basically that was your only remedy. You had no other remedy. You know, you could go to the manufacturer's philosophy was string the consumer along as long as we can, either sell them a matching tow truck, or, you know, eventually they will fade into the distance, they'll get rid of the car, they'll come and buy another car. That philosophy, by the way, has changed dramatically. It has changed dramatically. Although sometimes one wonders in light of the, you know, the present news that one reads about all of the questions of quality in the cars, but there has definitely been an increase in the quality of the car, cars being manufactured, and the programs, not only in this state, the new car programs, but in our sister states, the number of cases coming in have drastically been reduced. So while our paralegals, when we started, were really handling truckloads of cases, today that's not the case. We're getting a steady stream of cases, particularly interesting on the luxury cars, I notice. Do you notice that, Joe? That
yeah, Aston Martin was one that is in New York.
Okay. That's not to leave out the other guys, you know, GM and Ford and the rest of the gang, but somehow we're not unique. In checking with our sister states administrators, their programs have been diminished. And I always remember that Bob Abrams said, you know, Sandy, the success of the program is that eventually we won't need it because manufacturers will come to adopt a philosophy of satisfying the consumer before it gets into an arbitration or a court hearing. By the way, I am not going to get into it, but I will say this, that the law has provisions that if a manufacturer has to return a car, that information has to be conveyed to the motor vehicle department. The title has to be surrendered, and the title has to be what we call branded. So if a subsequent purchaser purchases that car from a used car dealer, they are purchasing a car, they're getting notice they're purchasing a car that has been subject to the Lemon Law. People, of course, are going to be hopefully reluctant to purchase that car, although the manufacturers have always argued, well, you know, we fixed it up and it's ready to go. But we need not get into that detail. The way we first drew the law, we covered new cars. We added subsequently motorcycles. So we're talking about new cars and motorcycles. We're not talking about things like off-road vehicles, you know, snowmobiles and I don't know what other off-road vehicles there are, but we're talking about, and we're not talking about trucks. We're talking about passenger cars. That includes SUVs, etc. I think that I'd like to read you what I consider an excellent summary of the new car Lemon Law, and then talk a little bit about amplifying some of the things, and then let Herb can amplify further. So, GBL 198A, which is the new car Lemon Law, obliges manufacturers to repair without charge any new motor vehicle which fails to conform to all express warranties during the first 18,000 miles of operation or for 2 years immediately following delivery of the vehicle, whichever comes first. If within that time frame a manufacturer is unable to correct the defect that, quote, substantially impairs, unquote, unquote, the value of the vehicle to the consumer, quote, after a reasonable number of repair attempts, unquote, the manufacturer, at the consumer's option, must either replace the vehicle or accept the return of the vehicle in exchange for a refund of the purchase. A presumption that the consumer has met the, quote, reasonable number of attempts requirement arises in two circumstances. One, if the same defect has been subject to repair for 4 or more times but continues to exist, commonly termed as the repair presumption. 2, if the vehicle has been out of service for a total of 30 days or more, referred to as the days out of service presumption. The triggering of either the repair presumption or the days out of service presumption does not ensure that a consumer will recover. A manufacturer may rebut the presumption and is afforded an affirmative defense when it can show either that the defect does not substantially impair the vehicle's value or the condition resulted from abuse, neglect, or unauthorized modifications or alterations of the vehicle. The condition of the vehicle at the time of the arbitration is not relevant in the court's, in the arbitrator's determination. So,
Could you read that last clause?
yes, the condition of the vehicle at the time of the arbitration is not relevant to the arbitrator's decision. What that means is, for a long time, the Attorney General, again, made a very grievous error, Attorney General being Herbert and me, in joining with the American Arbitration Association, writing the regulations, and taking the position that at the time of the arbitration, the vehicle's defect must continue to exist. How many years later, Herb?
I think 16?
How many?
16?
16 years later, we changed our minds. And we said, we didn't mean that at all. We mean that if you, the consumer, had 4 or more attempts, and the vehicle still remained unrepaired, i.e. the transmission still bucked when you put it into drive, after the 4th attempt, the fact that the consumer went back at the 5th attempt and the car was spiffy then, transmission ran like a top, doesn't matter. We used to say, oh, the condition, the fact that it's been fixed at the time of the arbitration knocks the consumer out of the box. And now that's not the case. And that case also, our change of mind went up to the New York Court of Appeals, and the New York Court of Appeals said, yeah, the Attorney General has a right to change their mind. And that's what the law really says. Attorney General was misinterpreting the law, but you know, everybody can make an error, right? So we are sort of humorous. Okay, let me talk about a few things. First of all, we're talking about the car. I said it doesn't include trucks, so commercial vehicles are not included. The car has to be the vehicle. I say car, I don't want to keep saying motorcycle. Has to be used, the words are primarily for personal and household purposes. Driving back and forth to work is not a commercial purpose. That's a personal use. But using the car for business is a commercial purpose. Well, you might say, how do we as arbitrators find out? Well, one thing that the arbitrators sometimes do is subpoena the tax records of the consumer. To find out if the consumer is claiming that this is a vehicle for a personal use, but they're taking a deduction, a business deduction for it. So it can have some commercial use, but the law reads primarily for commercial use. Now, I mentioned in this little summary the word presumption. Some other states have said if the car has been subject to repair for whatever, some say 3 attempts, 4 attempts, whatever it is, we say 4 attempts. That's enough. That's not the way the law is written in New York, as this little summary that I've read. We have created presumptions. Now, those of you who are attorneys know that what that means is that if the consumer can meet the presumption that the vehicle remains unrepaired after the 4th repair attempt, then the consumer can be deemed to have met their burden of proof, and now the burden shifts to the manufacturer to try, if they can, to rebut the presumption. Well, how do you rebut the presumption? Well, you can argue that this was a very, very rare problem, and we went to Germany or wherever, the expert engineers, or Japan or wherever, and we finally were able to find that, I mean, things like that. And on the other hand, the consumer can say, I want to come into the program even though I don't have 4 or more attempts, because I believe that this is a safety defect. I'm afraid to drive this vehicle. Every time I get into this car, the vehicle stalls out on the Long Island Expressway. I have kids in the car. All of a sudden, bingo, the car falls. I could get rear-ended, a terrible, tragic accident. So I want to come in after 2 repair attempts. That should be enough to presume that the vehicle is a lemon. So we would say to the consumer, look, the statutory presumption is that if it's 4 or more repair attempts, the burden, you've met the burden. If it's 2 attempts or 3 attempts, maybe the arbitrator will believe you've met the burden. That's something that the arbitrator has to decide. So that's what a presumption means. Now, the law is a warranty law. In other words, as I read, the vehicle must conform to the express warranty that is given by the manufacturer. Now, warranties are like accordions. They expand and contract. When we first had the law enacted, the warranty of the manufacturers was 12 and 12, whichever came first, 12,000 miles or a year. Well, as I read, the lemon law period is 18,000 miles or 2 years from delivery, whichever comes first. Today, Hyundai, I think, is offering 10 years or 100,000 mile warranty. So, I mean, the lemon law time frame has been surpassed by the manufacturers, but the own warranties. But the fact of the matter is that you look to the warranty. Does the defect not conform to the warranty? So, for example, if in one case, consumer argued that every time they came to a halt, the gas in the gas tank, you could hear a slapping noise. And the manufacturer argued this is a common characteristic of this particular car. If it's a common characteristic, then it's not a warranty defect. It's not covered by the warranty. And the courts, when these cases go up on review, the courts will knock down an arbitrator's decision if an arbitrator finds that the problem being complained of is a common characteristic of the vehicle. There are other cases, for example, to bring home the point of the importance of warranties. If there's a warranty, if we argue that the law's a warranty statute, then you know that you can modify the warranty. If you're giving a warranty, you have a right to modify the warranty. And some manufacturers have modified the warranty. For example, a common modification is that the warranty will not cover alterations made to the vehicle subsequent to its manufacture. So, what does that mean? That means that if a consumer buys a vehicle and has the dealer put in an option, for example, has the dealer put in an anti-theft, a LoJack anti-theft device, or has the dealer cut a sunroof into the vehicle, that's excluded by the warranty. And that kind of defect will not meet the requirements of the Lemon Law. Now you may say, well, so this is an open and closed book. The minute I see that there was a dealer-installed warranty, I can rule in favor of the manufacturer. No. There are a number of cases. In one case, for example, a consumer bought a car. The dealer replaced the wheels and the tires on the car. The consumer drove the car and the car shimmied when it reached a certain speed. The manufacturer argued excluded by the warranty. Not a Lemon Law win. Court, the arbitrator ruled, as I recall, in favor of the consumer, saying the replacement of the original tires with more fancy wheels and tires could have affected the shimmying. Court said not good enough. Sent it back to the arbitrator. It said not good enough to just say it could have affected. The arbitrator has to decide, even if there were an alteration made subsequent to the purchase of the vehicle, it can possibly be that that was not the cause of the defect that the consumer is complaining about. For example, if the electrical system was in itself screwed up, the fact that the dealer added a low jack may or may not have been the reason that the consumer was having electrical problems with the car. Now, in one case, I think it was the GM warranty read that the warranty said that any alteration, unauthorized alterations or additions made to the vehicle after the purchase of the car will exclude coverage. And the court nevertheless said to the manufacturer, you didn't say, you said that any alterations made by the consumer. Therefore, that's not an exclusion in the warranty. So the next day after that decision, they amended their warranty to say any alterations made by the dealer prior to the delivery would constitute an appropriate exclusion. But be aware that because you're dealing with a warranty law, you can nevertheless exclude what you want to exclude. But the fact that that which you're excluding, the defect which is being excluded, may or may not be the cause of the defect. Many, many times, I will say to you, if a consumer adds an option, that's going to be the cause. But the arbitrator must make a determination that that was the cause of the problem. Here's something very important. Law says, oh, by the way, when we were drafting the law, we said, well, consumer has the car. The car is a headache from the beginning. The consumer has to rent another car while the car is being repaired. Consumer has to stay over in a motel overnight, maybe it's stuck on the road. Various incidental damage. But the legislature said, look, we don't want to get involved with that. What we're going to do is, if the consumer elects, and this is at the consumer's election, to take a refund or a replacement. By the way, Herbert will cover this, but a replacement does not mean you get a brand new car. It means you get the same car that you're turning in. So if that car has 19,000 miles, you get, and it's last year's model, then the replacement would be to GM to go out and find the 19,000 mile car that was last year's model. Many times they can't do that. We recommend to consumers that they don't take the remedy of replacement, but some do. And then the manufacturers usually work out something with the consumer, some financial adjustments, so they get the consumer to take a refund. The first 12,000, there's a deduction for use in the, and Herb will go into that in much more detail, but the first 12,000 miles of use is given to the consumer as a gift. In other words, when you're calculating the refund, you as the arbitrator, the first 12,000 miles are free. That's to replace any claims that the consumer would have for all these incidental damages. Now, this is, I want you to know, it's the only opportunity I have to speak. I get home, bingo, that's it. I start do this, do that. Yeah. Did you take out the garbage? No, go down. We need bananas. You're not going to have bananas for your cereal. You won't be, you won't be constipated. You will be constipated. I don't know, whatever it is. Get the banana. All these things. So, I relish these opportunities to speak, to find out that I still have a voice. Not yet. Yes. Yes, dear. No, dear. Because after 50 years of marriage.
They're magical words.
But I'll tell you the secret. Whenever I argue with my wife, whatever it is, we argue. She says, it's black. I say, it's white. I always end it by saying, you may be right. I figure if I say, you may be right, even though it's burning me inside that she's wrong. Let her think she may be right. On to the next problem. Here's something very, very important. Here's a trap that I beg you, if nothing I've said to you means anything else, here's a trap. The language of the law means substantially, and I'm quoting, substantially impairs the value of the vehicle to the consumer. Let me repeat. Substantially impairs the value of the vehicle to the consumer. Now, some states, a number of states, have a different formulation. They say substantially impairs the value, use, or safety of the vehicle to the consumer. The value, use, or safety of the vehicle. Oh, and they don't add it to the consumer. Substantially impairs the value, use, or safety. Now, look at this, take this kind of a situation. A person buys a car, the paint begins to peel. Consumer goes back and said, paint is covered by the anti-corrosion section of the warranty. Manufacturer argues, you can drive that car. There's nothing that makes it unusable. Safety, car isn't going to get into an accident because the paint is peeling. So they'll say, Your Honor, Madam or Sir Arbitrator, there's no substantial impairment of use or safety. Don't be taken in by that trap, because that ain't the language of the New York law. Now, the New York law reads substantial impairment of value to the consumer. Why is that important? Why to the consumer important? Incidentally, Florida had that same language, to the consumer. They took that language out, to the consumer. Why is that important to have to the consumer? Because that injects a subjective component to the question of what constitutes substantial impairment of value, which is the key that you have to decide. So the answer is that in New York, and I've read the treatises and the cases, that term, by the way, substantial impairment of value, this is to show that I was not completely wrong when I said revocation of acceptance is akin to the Lemon Law. It certainly is akin to the Lemon Law, because that's where we took the language. We took the language out of the UCC. Revocation of acceptance is effective when there's substantial impairment of value to the consumer. That's where we borrowed that phrase from. So the way I've been able to boil it down from reading the UCC, the commercial law texts and the cases in other states, is that it has both an objective and subjective component. Substantial impairment is determined by, one, a subjective standard measured by the buyer's needs, circumstances, and reaction to the nonconformity. And two, an objective standard measured by such considerations as market value, reliability, safety, and usefulness of purpose. That's one definition. You'll find many definitions, but the point that is to remember that the fact that the vehicle may be safe and may be usable is not a consideration that you have to buy. So when a manufacturer's attorney, and they all do this, there's not just one or two cases, you'll see the manufacturer will argue. It annoys the hell out of me when I read arbitrators' decisions and I see them writing, there's no substantial impairment of use, value, or safety. Where'd you get that from? You're arbitrating in New York. Maybe you'd like to argue in Miami Beach, but sitting in Miami, but you're not. You're sitting in New York on, where are we now? Exchange Place, or wherever. Buffalo, Syracuse. Remember that. Don't be misled by that formulation. The New York formulation should be your guiding principle. Well, I guess there's a lot more I could say, but I'm sure you're tired of listening to me. So thank you for most of you staying up and hearing me.